Welcome to the Probate Nation. My name is Richard Ruddy. Probate is a process to transfer the title of probate assets to beneficiaries of a deceased person. To do so, you may have undertaken to get yourself duly qualified to probate those assets, and that authority works for probate assets located in the state where the decedent resided at the time of death and probate was initiated. Unfortunately, that authority does not automatically extend to probate assets in another state, such as real estate from a prior home not yet sold, or a beach house that was a second home. That authority can be acquired, though, through a process called Ancillary Probate Administration in the state where the assets are located. In the show tonight, we will learn the nuts and bolts involved in undertaking an ancillary probate in Florida, from how to initiate, steps to be taken after qualification, and how to wrap up the ancillary probate. With us tonight, we are fortunate to have a Florida attorney who will share her expertise and guidance on this topic. Our guest is the managing and founding partner at the Menendez Law Firm in Fort Lauderdale, Florida. She obtained her law degree from the State University of New York at Buffalo and her master's in taxation from Georgetown University Law Center. Before opening the doors of Menendez Law Firm, she worked for the Florida Department of Revenue, Deloitte & Touche CPAs, and the law firm of Holland & Knight. Her practice concentrates on tax, estate planning, probate, real estate, and corporate and business law. Please welcome Florida attorney Nydia Menendez. Welcome again, Nydia, for coming back and talking to us about ancillary probate. Tell us, because I think that's a term that a lot of folks are not familiar with. So just tell us, what is ancillary probate?
So ancillary probate is very similar to a regular probate, with the exception that the person who passed away, the decedent, is not a resident of Florida. And so the primary jurisdiction is the place where decedent resided, but there are assets in Florida, and it is a Florida court that has jurisdiction over those assets. So very similar to a regular probate, except that decedent is not a resident.
So let's talk about then, what are some of the common assets that might be subject to an ancillary probate in Florida?
The most common asset that I see is real property, not surprisingly. And once in a while, I will also see bank accounts and other similar assets.
Okay. So if we have those types of assets, what court do we go to undertake to do an ancillary probate?
The circuit court, the regular circuit court that would administer probate.
So that'd be the circuit court where the asset's located?
Correct.
Okay. So what is filed with the probate court to initiate ancillary probate?
So similar to formal probate, you file the petition, the death certificate, a certified copy of the death certificate, and the exemplified record from the court of primary jurisdiction.
And will the ancillary administrator need to be bonded with surety?
Typically, yes. Of course, bonding, most wills and trusts will say no bonding required, but the reality is that bonding is something that's within the discretion of the court. So when the court sees that the personal representative is not in the state, which is typically the case in ancillary, the court will typically require a bond. And
what can be done with real estate once the ancillary probate has been initiated?
So once the administration has been initiated, if selling the property is required, you can always petition the court for permission to sell. But it's very similar to a regular administration.
Okay. So if we're not going to sell, we would do some sort of a deed just to convey the property to the heirs under the will? Is that what happened next?
Yes, you could do once the personal representative is appointed, the personal representative can do a personal representative deed, or you could wait for the court to distribute the property to all the heirs, to all the beneficiaries.
Okay. And are all ancillary probates going to be a formal probate?
No, not necessarily.
Okay.
If it's past 2 years, it's possible that it could be a summary.
Okay, that's good to know. I think because people will know that there's two types of probate, so that's good to know. Now, so once the person's been appointed the ancillary administrator, ancillary probate personal representative, what duties does he or she have?
Very similar to formal. Duties to creditors, to serve known creditors, to publish notice, if it's applicable, because let's keep in mind that the primary probate is being done in the county of, or the state of original jurisdiction. So very similar. You just have to notify creditors, you have to notify heirs, and make sure that you get the consents that you need, the waivers that you need, and that all parties that are interested have notice.
Okay. Now, does the personal representative have to file an inventory as well?
Yes, they do.
Okay, and then they still will have to file an accounting when it comes time to wrap up the estate as well?
Yes, they do. Or again, they could get a waiver.
Okay, so I mean, I think that's important for folks to understand that there is some ability to get some of these things waived, but I don't think I think you told us we can't waive off the inventory. Is that right?
Right. The inventory is a requirement. Even to file the petition, you have to say what you believe is part of the inventory of the state.
Okay. Okay, that's good to know. So once we finish up, that's common assets. We talked about that. Talked about the duties. Tell me a little bit about the process to wrap up an ancillary probate. What do we have to do?
Again, in order to wrap up the probate, you want that coveted order of discharge. And to get the order of discharge, you have to prove to the court that all notices on creditors have been served, that all beneficiaries have been served, and that they have received the assets that they want. So that's where receipt from beneficiaries comes in. And basically just make sure that all the services, all the statements regarding creditors, satisfactions of claims, receipts from beneficiaries, and accounting or waiver of the accounting.
Okay, so I mean, I think we certainly learned this when we did the initial show about Florida probate generally, that there's a lot of things to be done here, even though it seems like a simple process. In order to get that discharge, you have to be able to prove a bunch of different things, and they just don't take your word for it. So now, are there checklists online that can help people to know what they have to do, typically in the court's websites?
Maybe, sometimes, it depends. So one of the distinguishing features about probate is that every county is different. And so I know that Broward and Miami-Dade have checklists, and actually Palm Beach does as well. But I'm currently doing a probate in another county, no checklist. So when there is no formal checklist, you have to make sure that you check that judge's instructions. Perhaps the judge has additional instructions. So there really is no checklist per se. You have to really follow the requirements of the statute, and then go on a court by court basis, judge by judge basis, to determine which steps you need to take.
Well, this is I think one of the challenging things I'm finding with the Florida probate process, that there can be some inconsistency when you go from court to court as far as how they do that. But let's talk about how I'm not a resident of Florida. But I have assets down there. What can I do to avoid probate? So talk about, if I don't plan appropriately, let's go back here. If I don't plan appropriately, what's it typically going to cost to do an ancillary probate in Florida? Let's go back there.
So it's going to be the same cost as a regular probate. So if you've done a probate in your home state, you're going to double the cost pretty much, because it's a completely new probate. And so the fees that I typically tell clients to expect to pay is no less than $3,500.
Okay. Well, that's important to know. So then what can I do to avoid Florida ancillary probate if I own real estate in Florida?
So if you own real estate in Florida, you basically would have two options, right? Number one, properly fund it into your trust, or the second option would be to do a life estate deed. And of course, the consequences and the implications to either option are very different. So, but there are planning options, and the point is you can avoid probate.
And that's good to know. But now the other side of that particular discussion, though, is I'm a Virginia resident, and I have a Florida beach house or a Florida second home, and I decide to sell my house in Virginia and move to Florida because I can telecommute now. Okay, so I now become a Florida resident, but I have all these great Virginia documents that I had done. Okay, so tell me what kind of problems I can face. Let's just start with my Virginia revocable trust. Is that still going to be good in Florida?
Maybe not, most likely not. So if you're going to make Florida your home state and you have a trust from another jurisdiction, then you really should update your trust to make sure that the property that is funded into it, your new homestead, that there's proper language that the county appraiser's office will accept, the tax collector of the county will accept to give you that coveted homestead exemption. So, and they review it, right? Because property taxes are a revenue generator. So they want to make sure that if you are claiming the exemption, you are in fact entitled to the exemption, and there has to be language in the trust that will allow that to be the case. Yeah.
So typically, I think what happens then, people will, what they're going to do that, they don't have to retitle everything, but they have to basically amend their existing trust and basically redomesticate it so that the new law that governs that might be Florida possibly, so that then you can add whatever language might have to go in there. But we talked about the other documents that people have, which there's a will, a power of attorney, and I think especially the power of attorney, we talked about the importance of that financial power of attorney, even if you don't have a revocable trust. The financial power of attorney might be something even more critical. We want to make sure it gets taken care of. Can you share some comments about that?
Absolutely. And I love the fact that you said even more critical, because let's face it, the durable power of attorney is going to be active while you're alive. So absolutely, it is more critical. In 2011, our legislature amended the power of attorney to have these things that we refer to as superpowers. So you really want to make sure that you have a current durable power of attorney that's recognized in the jurisdiction where it's going to be used. So very important to have the durable power of attorney for more reasons than one. Number one, it's what governs while you're alive. Number two, the local, the current documents are very different from what used to be several years ago. And number three, we all know that banking institutions and other organizations love to deny the power of attorney. So having it current and with the local jurisdiction is critically important.
So I mean, the other document I want to mention, of course, I think the healthcare power probably is equally as important. But if you're going to have a will, whether you have a will that's what we call a pour-over will or a regular will, are there special provisions that go into Florida wills that we have to make sure are there in order to allow that will to be admitted to probate?
Well, we talked before about the self-proving affidavit, and absolutely you want to make sure that there's that final declaration that all the witnesses signed in the presence of each other, and that they were validly identified by way of a notary. So you definitely want that, and you want that pour-over provision, and more, you want the qualifying language for purposes of doing Medicaid planning. At least here in Florida, we have so many seniors. So I always recommend updating documents whenever I get clients from another jurisdiction that have already planned.
Well, that's very, very important. And I know that I've had a number of clients that have property that they bought in Florida, and they're kind of splitting their time between Florida and Virginia right now. But I'm not sure that they have done anything special to make sure that they have the benefits of the Florida homestead exemption. Now, can you write in that special clause even though you don't make it a Florida document? Can you write language into the trust to cover that?
I'm sure you can. It's I do it by way of two separate clauses in my instruments. So I'm sure that you could write in language, but do you really want to gamble with something like that as opposed to making it specific to your home state, which is what the tax collectors really want to see in there?
I agree with you. I agree with you. And I think I start to probe that a little bit. Let's talk. We've covered a lot of ground because we discussed all about the formal and informal and informal probates. But ancillary administration becomes a lot more complicated because you're layering two different probates on top of each other, and so you got to make sure that the documents that are being delivered from the home state jurisdiction comply with whatever Florida may require. As you look back and we talk a little bit more about ancillary probate, tell me some of the closing some thoughts that you have about what people should do, how they should handle things in order to avoid the cost of a second probate. In effect, that's what you're talking about.
Yeah, so the cost and the headache, right? Because what you're going to have is you're going to have a personal representative that's done it already in one state this way. And now I'm saying we have to redo it in Florida that way plus this other way. So it's not just the expense, it's really, really intrusive and just getting so many ducks aligned. So again, what I always like to say is plan, plan, plan. And there are ways to plan, right? So to avoid ancillary probate, a will is not proper planning. We've talked about that. Obviously, properly funding property into a trust or even a life estate deed would do the trick, and they would each have different consequences depending on which alternative you choose. But the good point is that both alternatives would help avoid probate.
Well, I think that's good advice. That's good advice. The cost of pursuing ancillary administration. I know we've done it recently in Texas. We had to do it in Arizona. Again, real estate. It was generally the asset, the cost can be costly to say the least. Now, in the case of Florida, if I wait and don't come to Florida for a couple years after someone has died, do I automatically able to cut off the creditors because I go in and I can do like a less formal probate because 2 years has passed since date of death?
Yeah. In Florida, creditors have 2 years from the date of decedent's death to file claims against that estate. If a petition for probate has not been started, a creditor can actually be the petitioner and open the administration that way. So yeah, the 2 year date of death is an absolute bar to claims of creditors, and sometimes that's what some petitioners, some beneficiaries choose to do.
Okay. We've covered a lot of material. We have a little bit of time left over. I thought I'd ask you if you had any sort of additional thoughts you want to share about, the ancillary probate process and the planning that goes with it. I know we wanted to make sure we didn't miss anything, and I didn't want to not give you enough time to kind of touch on some of this. So if you have any other thoughts you want to share with us, I'd be delighted to hear those.
Yeah, so just in general, I recap and I say plan, plan, plan. Leaving your affairs organized is really the sign of a good steward, right? You'd rather leave a good legacy than a mess. Two very easy, simple ways to plan. If you already have planning in your home state, please make sure to take care of properties in other states. That is a benefit of having a trust. But if you have not done that type of planning, then do consider the life estate deed because it is relatively simple to do and it will avoid a lot of expense and headaches for your loved ones. And of course, if you're going to be transitioning from one state to the other, updated documents like the durable power of attorney that you talked about, very, very important to have it up to date.
And to talk a little bit about that one document we didn't chat about, the medical directive or medical decision-making document, is that very Florida specific? That, in other words, would I have problems bringing my Virginia healthcare power of attorney down to Florida to get some hospital to accept it?
What I find is that documents from state to state have a lot of similarities until they don't, right? The nuances. So, for example, the living will in Florida, in order for the living will in Florida to be valid, it has to state who has the authority to make the decisions. So I'm not sure if that's a requirement in other states. Some states split it, right? They say what the decisions can be made, and then you might be able to have a different document as to who can make the decisions. Well, in Florida, if your living will does not have the people that can make these decisions for you, then it is not really an effective document. So I would say that there are a lot of similarities across the state, but the reason you want to get a current document for the state in which you're going to be in is because there are a lot of nuances from state to state as well.
Okay. Now, we have certainly seen some clients who actually will do, in the case of this, will do a power of attorney and medical decision-making document in the state where they live, and they'll do another one in the state where they have property, where they have their second home because of this, what you talked about. Do you see that as well?
I do, and I love to see that because the client is going to be ready no matter what or where.
It's true. Well, look, we're about the end of our time today. I thank you for sharing all this information, especially for allowing us to have a conversation about some of the things folks should do, when they decide to uproot themselves from their home state and go ahead and move to the great state of Florida. That there are things that they ought to do, again, as part of the planning process. And again, I agree with your statement of plan. It really makes a difference when things go badly. So I want to thank you for, on behalf of the Probate Nation, Nydia, for taking the time, to visit with us again, to share with our viewers the work that will need to be done in a Florida Ancillary Probate Administration, and to point out, a state document that they should update if they should relocate to Florida. All this is very valuable information and a great public service for those viewers who need to undertake a Florida ancillary probate or who plan to relocate to Florida in the years ahead. So thank you again for taking the time to visit with us.
Thank you for having me. Great show.
You're very welcome. Without a doubt, probate can be complicated and time consuming, and this is especially true if you need to probate assets in another state through a process called ancillary probate. Many non-residents of Florida own second homes in Florida, especially beach houses. And our show tonight introduces you to the process that will need to be undertaken should you need to probate that Florida beach house owned by a deceased loved one. While the process seems consumer-friendly, I would be remiss if I did not emphasize the importance of consulting with a local Florida attorney about any ancillary probate you may need to initiate. The guidance of an experienced professional will help you avoid unnecessary work and pitfalls for the uninformed while shortening the time you ride the ancillary probate train in Florida. Hope you found this show helpful should you need to probate a Florida estate. And remember that replays of this show and all shows today can be viewed on the Probate Nation website. This brings us to the conclusion of our show. On behalf of the Probate Nation, thank you for visiting with us.